The tension in the Supreme Court chamber wasn't just palpable, it was historical. As Congresswoman Jasmine Crockett stepped up to the podium, a hush fell over the courtroom. She wasn't just a freshman legislator from Texas. She was a seasoned civil rights attorney with a voice that refused to tremble in the face of authority. Today, she wasn't defending a policy. She was defending a principle: the right to vote, equally, fairly, and without fear. She had come to present an amicus brief in a case that had already divided lower courts and dominated national headlines: Jefferson County v. United States. The case centered on a controversial new voting law that many claimed disproportionately suppressed minority voters. Crockett had seen the effects of similar laws up close. She had represented the elderly turned away from polling places, students forced through bureaucratic mazes, and entire communities whose ballots had been silenced not by bullets, but by bureaucracy. But what happened next was something no one, not even seasoned court reporters, expected. As she calmly detailed the law's disparate impact on minority communities, citing evidence, legal precedent, and historical context, Chief Justice John Roberts leaned back in his chair, smirked, and said, "Congresswoman, with all due respect, this court has heard these same arguments for decades. The data simply doesn't support your position." And then he laughed. The Chief Justice of the United States Supreme Court, a man sworn to interpret the Constitution impartially, chuckled at a sitting Congresswoman's concerns about racial discrimination in voting. For a heartbeat, the courtroom was silent. Not the kind of silence that invites reflection, but the kind that chokes it. Most would have faltered. Most would have backed off, retreated to prepared remarks, or fumbled forward, shaken by the disrespect. But Jasmine Crockett isn't most people. She paused, took a breath, and then she looked Roberts directly in the eye and said, calmly but firmly, "Mr. Chief Justice, with deep respect for this court and its authority, I must strongly disagree." And in that moment, something shifted. Not just in the room, but possibly in the course of American legal history. This is the story of a Supreme Court showdown unlike any in recent memory. It's about how a black woman from Missouri, armed with nothing but facts, precedent, and unshakable conviction, forced the nation's highest court to listen. It's about the audacity to stand firm when every power in the room dares you to shrink. And it's about why democracy doesn't die all at once. It's chipped away slowly, vote by vote, unless someone refuses to look away. So before we dive into what happened next, before we walk through the evidence, the arguments, the confrontation, and the ruling that stunned the country, let's remember what was at stake. Not just one case, not just one law, but the foundational idea that every voice in a democracy should count, and count equally. Because in 2025, in the heart of Washington, D.C., inside the highest court in the land, a woman stood up for that idea and refused to sit down. The courtroom was still. The Chief Justice had laughed, but Jasmine Crockett hadn't blinked. She had stared directly into the eyes of the most powerful judge in the country and refused to be diminished. Now it was time to fight the battle she came prepared for. She set aside her notes. "Your Honor," she said, voice unwavering, "I did not come here with generalizations. I came with data, with precedent, and with the lived experiences of Americans who have been systematically shut out of the democratic process." Then she began. First, she walked the court through county-by-county data, showing that black voter turnout in Jefferson County had dropped by 27% after the voter ID law went into effect. White turnout had dropped just 3%. "This isn't coincidence," she explained. "It's consequence." She showed maps, statistics, affidavits. Not from lobbyists, but from voters who had stood in line only to be turned away. Chief Justice Roberts leaned forward slightly. He wasn't smiling anymore. Justice Thomas cut in. "Correlation does not equal causation, Congresswoman. Could these numbers not reflect other socioeconomic factors?" Crockett nodded. "That would be a fair question, if we didn't also have direct evidence of discriminatory intent." She reached for a folder labeled Internal Communications, Jefferson County Election Board. With deliberate calm, she read aloud an email. "The beauty of these ID requirements is that they look neutral on paper, but we all know who they'll really affect." The silence in the courtroom deepened. She wasn't finished. Crockett pulled out a Justice Department analysis, completed just weeks before the hearing. It had controlled for every variable, income, education, transportation access, and still found the voter suppression disproportionately harmed minority communities. "This data isn't anecdotal," she said. It's statistically significant at the 99% confidence level. Roberts shifted uncomfortably. And then came her boldest move yet. "Your Honors," she said, raising another document. "This is a side-by-side analysis conducted by the Congressional Research Service comparing modern voter ID laws with Jim Crow-era restrictions." She turned the pages slowly, showing images of poll taxes and literacy tests, and their modern equivalents. Long lines in minority precincts, ID requirements that cost time and money, voter roll purges executed without notice. "This court has often asked whether modern restrictions are truly comparable to the past," she said. "This report shows that while the tools have changed, the target has not." Even Justice Barrett leaned forward now, intrigued. "Congresswoman, how do you respond to the argument that some burden is inevitable in any voting system?" Crockett didn't hesitate. "The burden isn't the problem. The distribution is. When 70% of the burden falls on 30% of the population, specifically Black and Latino communities, that's not evolution. That's exclusion." Justice Alito's tone sharpened. "Are you accusing this court of indifference to voter rights?" Crockett looked him in the eye. "No, Justice Alito. I'm reminding this court that indifference is not always loud. Sometimes it looks like neutrality. Sometimes it sounds like silence." There was no applause in the Supreme Court, but the energy in the chamber had shifted. The justices weren't just listening now. They were reevaluating. In just 20 minutes, Jasmine Crockett had turned a dismissive smirk into careful consideration. She had forced the highest court in the land to confront the uncomfortable truth behind neutral laws. This wasn't just a legal argument anymore. This was a reckoning. When Jasmine Crockett finished her final statement, the courtroom sat in rare, absolute silence. No scribbling of pens. No whispers among aides. Even the justices, typically composed and measured, looked visibly shaken, not by theatrics but by truth laid bare. Chief Justice Roberts, who had started the session with a smirk, now held a pen in midair, frozen. The laughter that once echoed across the chamber had evaporated, replaced by something much heavier: the burden of undeniable evidence. Justice Sotomayor was the first to speak after Crockett sat down. "This court appreciates the clarity and depth of the Congresswoman's presentation," she said, her tone firm. "What we've heard today will not soon be forgotten." The hearing wrapped minutes later, but the echo of Crockett's words lingered far beyond the chamber. That afternoon, legal analysts flooded the airwaves. CNN's legal correspondent called it a historic rebuke of dismissiveness at the highest level. Conservative outlets, while hesitant, admitted that Crockett's evidence demanded attention. Social media exploded. Hashtags like #CrockettClarity and #TruthInTheCourt trended for hours. But the most dramatic shift occurred behind closed doors. Sources later revealed that Chief Justice Roberts convened a rare extended conference with the other justices that same afternoon. Instead of the usual 30-minute post-hearing discussion, they debated for over 3 hours, grappling with the new evidence, the tone of the hearing, and the future of the court's voting rights jurisprudence. 3 months later, the decision dropped. In a 6-3 ruling, the Supreme Court struck down the central provisions of Jefferson County's voting law. Roberts, writing for the majority, admitted what few expected. While the court has previously emphasized the legitimacy of fraud prevention, it cannot ignore the clear discriminatory impact of the provisions in question. Neutrality in text does not excuse injustice in practice. The opinion quoted directly from Crockett's arguments, even citing the Congressional Research Service document she introduced. It established a new framework, one that required states to prove not only that their voting laws were written neutrally, but that they were enforced equitably. It was a seismic shift. In the weeks that followed, civil rights organizations filed challenges in 5 other states using the Crockett standard. Jefferson County's own Board of Elections began rolling back ID requirements and reinstating early voting. Voter participation soared in the next election cycle, especially among previously suppressed communities. As for Crockett, her life changed overnight. She was invited to lecture at Harvard and Yale on constitutional law. Her congressional colleagues, even those from opposing parties, approached her with newfound respect. But Crockett didn't bask in the spotlight. Instead, she returned to the work. "This wasn't about making headlines," she said in an interview on MSNBC. "This was about reminding the court and the country that justice doesn't arrive politely. It arrives when someone's willing to be uncomfortable." A year after the ruling, she returned to the Supreme Court, not as a litigator or lawmaker, but as a guest of honor at a lecture on civil rights history. A student asked her if she had been afraid when Roberts laughed at her. Crockett smiled. "Of course I was afraid. But courage isn't the absence of fear, it's what you do with it." Then she added something that would later be carved onto a plaque at Howard University's law school. "If the law forgets the people it's meant to serve, remind it. Loudly, respectfully, and without apology." And that, in the end, is what Jasmine Crockett gave the country. Not just a legal victory, but a blueprint for moral courage.